Got enough folks here. Sounds like a few people are running a little late coming back from lunch, so go ahead and get started. Do we have any requests for bill introductions today? All right, not seeing any. We'll move on and we'll open the hearing on House Bill 2068 and ask Natalie to give us an overview.
Thank you, Mr. Chairman. House Bill 2068 would modify how certain prior convictions are counted for the special sentencing rule that's related to possession of a controlled substance. And it also provides for concurrent or consecutive sentencing for persons convicted of new crimes while they're on release for a felony. Section 1 amends KSA 216606. Current law in subsection D here provides that if a person is convicted for a new crime while on release for a felony, then that sentence for the new crime has to be served consecutively. This bill would allow the sentence for the new crime to be served concurrently or consecutively as the court determines is best there. Section 2 amends KSA 216805 to amend the special sentencing rules in subsection E related to the manufacturing of a controlled substance, and subsection F, which is related to possession of a controlled substance. Current law in those rules provide that the sentence for a second or subsequent conviction and the sentence for a third or subsequent felony conviction shall be enhanced. This bill would change that language to apply the special rule when that person is being sentenced for one or more prior felony convictions in subsection E, or when that person is being sentenced, has two or more prior felony convictions up in subsection F. And I can take any questions.
Questions? Representative Heiberger.
I'll ask the Carmichael question. Have we seen this before, and could you refresh us on the bill number so I can recycle my bill brief?
Yes, you have. Mr. Chairman, I was like scrambling around trying to find the bill number, and I'm guessing that Scott knows it off the top of his head. So if he doesn't say what it was, then I will find it for you.
Thank you. Additional questions? All right, seeing none, we'll go ahead and welcome our proponent, Scott Schultz, Executive Director of the Kansas Sentencing Commission. Welcome, Scott.
Thank you, Mr. Chair, members of the committee. Happy to be with you this afternoon. House Bill 2081 from last year would be that bill number. That was, you actually passed that out of this committee, and it actually passed the House last year as well, and then got stalled up in the Senate. I kind of wanted to I wish we would have started off on a little easier bill, but this is more from the last time I talked with you, talking about the guidelines being kind of complex when you're not working with them on a regular basis. The last time that I visited with you, we talked about the sentencing grids, the non-drug grid and the drug grid. Under the Sentencing Guidelines Act, there are how the folks are actually sentenced within the grids, but then there are actually carve-out provisions called special sentencing rules. And over the years, we have created 48 of those, the legislature has. And so we are going to be talking about 3 of those today. So again, they're carve-outs so that if I fall into a probation box, if certain conditions are right under statute, it can actually be presumed prison instead. So even though I fall in that presumptive prison or presumptive probation box, I can actually receive a prison sentence. So with that, I kind of like to break this into kind of 2 sections. The first is a little bit more timely. The second is more of a technical fix that we did. So the first one deals with Special Rule 10. Natalie did a great job, as usual, of talking about that. But what happens in situations of this particular, if you look at the bill itself, it talks about what happens in instances of if I have an individual that is already on supervision of some sort. Is there anything new that happens to them sentencing-wise on this new case if, for example, in subsection B, a misdemeanor actually occurs. If I'm on probation in subsection C and I commit another crime, what happens then? Well, in that case, if it's a felony, you get consecutive sentences. And if I'm incarcerated and I commit another offense, it's actually consecutive to whatever sentence I'm serving. So what we're talking about is what happens when I'm on felony bond and I commit a new offense. Currently, the law specifically requires the court, it is mandatory, there is no discretion whatsoever for the court to actually do concurrent sentences. The law specifically provides for consecutive sentencings in those cases. No ifs, ands, or buts. So there is no leeway. And one of the things that we want to kind of bring up is, each of these cases are fact specific. And so in certain situations, there may be occasions when the judge may want to actually run them concurrently or together versus consecutively, one after the other. And, I think of an example right now specifically of the individual gets arrested for possession of meth, for example, has an addiction issue. They get placed on felony bond. They've got to use, and by the end of the week, they're picked up again on felony meth possession. Under those circumstances, because they were on felony bond for that first one, the court is automatically going to have to run those sentences consecutive. If we look at that and the judge has an opportunity to say, this person has an addiction, needs treatment, but I have no other choice but to run these consecutive, it doesn't make a whole lot of sense in that particular situation. And there may be other examples as well. Now, certainly under the law, if I'm on probation, if I'm out on parole and I commit a new felony now, sure, those should run consecutively with each other. But where I'm on felony bond, I've not been adjudicated yet, as I basically am presumed innocent until proven guilty. The commission feels strongly that the court should have discretion. And so the only thing on that first page of the bill on line 36 is we're asking that be allowed as far as discretionary, as far as concurrently be placed in there, as well as court can still run it consecutively, but they just have the option to be able to do that. If we look at the numbers themselves, if you look at my testimony, currently we have, last year we had 1,216 offenders that were subject to this specific special rule, easy for me to say, in which only 60% of those actually received consecutive sentences. So in some of these cases, the court is actually not even following this particular provision, probably for equity purposes, most likely. So that we would actually respectfully request that those actually be simply put concurrently or be placed in that particular subsection. Now, the second part, again, is Special Rules 12 and Special Rules 26. And these are drug special rules. Special Rule 12 has to deal with, and this is on page 6 of the bill. Both deal with drug convictions, but the first actually is Special Rule 12 deals with manufacture. We don't have a whole lot of those because the legislature did things as far as taking ephedrine away, putting it behind the counter, those type of things. That has reduced the number of manufacturing cases. Plus, it's cheaper for the Mexican cartels to actually ship it up through here rather than actually making it here. So, for example, we had 2 convictions for manufacture last year. This particular special rule is important because it actually puts the hammer down on folks that want to reoffend with regard to manufacture. And so the substance of this particular provision is not changed. It actually is just done to reflect specific language that the Sentencing Commission or the sentencing guidelines actually holds as a term of art, which is a prior conviction. In several other special rules, we use the term prior conviction, and this is any conviction other than another count in the current case, which was brought in the same information or complaint or has been joined for trial. And so This is specific because that's how we count criminal history. And so the whole purpose of these special rules is to actually invoke more punishment based upon the conduct, repeat conduct of individuals. Here, the manufacturer, it's simply, we're restating it. We're not adding or subtracting, we're restating it with the prior conviction language so that if you actually receive a second manufacturer, this is your second manufacturer conviction, you are subject to not only presumptive prison, because the law provides anytime you have a manufacturer, you're not subject to probation, community corrections, or any type of conditional release. You have to serve prison, but it also allows for twice the maximum sentence. So it's a pretty punitive type of subsection. So again, not changing the substance, we're actually just changing the prior language. I will say the same thing with regard to the Special Rule 26 on page 7. This has to do with a third possession of controlled substances. So if I have 2 priors already, then I'm subject to the special rule, which is presumptive prison. Again, we're not changing the substance, we're just utilizing that prior offense or prior conviction language that would actually make it consistent with several other of the special rules, such as Special Rules 27 and 29 that deal with burglary, thefts, multiples of that as well. Why? What's the point? What's the point, I think, is probably the key here of these last 2 rules. We've had instances in which, for example, we have someone that is convicted of 3 possessions of controlled substances in one case. The judge basically sentences the first 2 and then applies the special rule to the third. That's not the intent of the statute. And so folks are potentially going to prison that shouldn't be going to prison on their first go-round with, now granted, you know, there are three counts of that, but the point or the legislative intent of this is that they have prior convictions that now they have a third one and they're going to need to be punished with a presumptive imprisonment. So we believe that this actually, and hopefully I sort of did that in this testimony, cleared that up, but it makes it easier for the practitioner to know I need to have on Special Rule 26 2 priors or more for this to apply. On the manufacturer, I need to have at least 1 or more manufacturers for that particular special rule to apply. Again, as far as Special Rule 26, we actually have 406 offenders from last year in which this was applied. 3/4 of those were actually sentenced to probation. About a quarter or so were sentenced to prison as a result of that. So, so again, kind of a complex one to start out with, but I certainly, if you do have questions, I hopefully be able to answer those and stand for questions.
Thank you, Scott. Committee questions? Yep. Representative Smith.
To argue semantics, I know we've gotten into the discussion before in law enforcement about the idea that an individual is going to court with the 2 prior convictions, and whether we're talking about theft or we're talking about controlled substances or what it is. So in a previous case, they have 2 counts against them, right? And so the question, we have to explain often that it's not 2 convictions then. Those 2 counts count as 1 conviction, am I correct?
Yes, you're not, because you're actually in the same case, you can't actually count those as priors. And that's, again, that's specifically in law that prior conviction, that, again, is a term of art that requires that to be a previous event, not in the current case in the complaint information.
Thank you. Any other questions? All right, seeing none. Thank you, Scott. We'll see you here in a minute. We'll now welcome Jennifer Roth on behalf of the State Board of Indigent Defense Services. Welcome to the committee, Jennifer.
Thank you. My name is Jennifer Roth, and this is the first year that I'm appearing as part of the BIDS Legislative Committee. We are new this year, but I have been coming here. This is my 19th session. I'm a deputy appellate defender, and I've been an attorney for almost 25 years, always practicing criminal defense. And I wanted to speak briefly about part of 2068, and that is the Special Rule 10 that Scott was talking about. And this clarifying this rule, this particular subsection is important more than it ever was in the last 23 years. And that's because when, maybe I shouldn't speak for Scott, but when he says the law makes it mandatory, what I believe he's talking about is a Court of Appeals decision that looked at this legislature's statutes in, I'm going to use some numbers here, but in 6604, in my testimony, I lay these out. But basically, the court looked at the statutes that this legislature passed almost 23 years ago and decided that they don't conflict. One controls over the other. And so that is why it's important for this legislature to clarify and to say exactly what it means. And I believe this legislature, not you particularly, did that 23 years ago in 1999. And what happened that year, and this is attached to my testimony, is you had the AG's office and the District Judge Association come here and say, we want to be able to make sentences consecutive when somebody commits a new crime while they're on bond, but they did not take away the idea that it could be concurrent. When you look at the testimony and when you look at the way that the legislature worded the subsection in 6604, that was a discretionary decision that judges could make. And so it is our position that we've been acting, and when I say we, I used to be a trial attorney before I was a appellate person. And so I practiced in Shawnee County for 13 years. And that whole time, we always believed that the court had discretion under 6604 to run a person's cases concurrently if the situation called for that. And so it is our belief that the legislature told us in 1999 what they wanted it to be, and we are asking that you codify that now so that it is clear that judges have that discretion. And I'm going to tell you the same thing that I've been saying for 18 years, and I'm going to tell you the same thing tomorrow, and that is this: that when you think that there's some situation that could never warrant a departure, or surely there's some situation where a judge shouldn't have discretion, I respectfully disagree. As Scott said, these things are these cases are as different as the people involved. The judge has the person before them. They know the facts of the case. They know the person before them, and they should have the discretion to decide whether this person needs to have their sentences be consecutive or not. One other point, I thought it was very interesting when Scott said that 60% of the time courts do not impose consecutive sentences, thus suggesting to me that, in fact, lots of us know that 6604 authorizes it. But more importantly, can you imagine the impact on prison costs and prison beds if that special rule was in fact mandatory and was imposed imposed every time? That's 60% of the people had their sentences concurrent. I shudder to think the cost of codifying this to be mandatory consecutive. I think that is everything I wanted to say. If I could, Representative Smith, you asked a question of Mr. Schultz, and if what you mean is in the future, if those two counts in one case count as one or two, like in the future, they'll count as two. But if you were talking about the present case, I just wasn't sure. I was like trying to see the wheels turning. But if what you mean is that somewhere down the road, a person picks up a new possession charge, if they have two priors in their past, I mean, Scott can tell me if I'm wrong, but those, normally, we would consider those to be that you had two priors. Am I wrong, Scott?
Representative Smith?
Okay.
To clarify my question, when we make an arrest on an individual, deciding whether or not we're arresting him for a misdemeanor or a felony, we have to determine, was that 2 counts, 1 conviction, or was it 2 convictions? So is this the 3rd conviction if we were to, when we arrest him, is this going to be the 3rd one, or is it only the 2nd because those 2 counts were on 1 case?
No, if this is in the past, the person has been convicted, they didn't even have to be sentenced. If they've been convicted in the past, and you are about to arrest them on a charge, if they have 2 convictions, whether they were in 1 case or not, this one is their 3rd. Anyway, sorry to get off topic, but I'm just asking, we are asking that you, that we urge you to codify what we believed the law has been for 23 years, and that is to give judges discretion when considering people who have committed a new offense while on felony bond. Thank you.
All right, Representative Carmichael.
Thank you, Mr. Chair. Pardon me for my ignorance, but help me clarify this. Just by way of example, let's say I go on a spree, all right, and I run over to El Dorado, and I commit a couple of offenses over there, and the next day I'm back over in Wichita, and I do a 3rd one over there. And so now I get charged over in Butler County on a 2-count indictment for doing whatever this bad thing was. And I'm charged in Sedgwick on a 1-count indictment for subsequent conduct, but prior to conviction on the Butler County charges. Does this kick in? Does it not kick in?
It only kicks in if you were on bond. So if, let's say you're in Butler County and you can go on a spree, and that's going to have its own consequences. And judges, honestly, down the road, if you get convicted, they have the discretion to run those concurrently or consecutively as a separate matter, which will come up tomorrow. But to answer your question, if you go to Butler County and they arrest you for those 2 things that you did, and you bond out, and then you go to Sedgwick County and you do whatever you do in Sedgwick County, then the Sedgwick County judge, if you get convicted, can consider the fact that you were on bond in Butler County.
On bond, but not with reference to whether I was convicted of the crime or had even committed the crime, just the fact I was on bond?
Right, which leads to it, right, I think I see what you're getting at, which leads to one of the other points I tried to make in my written testimony, which is, if we believe in the presumption of innocence, then when a person is on felony bond, they haven't been convicted of anything in that case. I mean, I'm not getting into the weeds here, but in simplest terms, if I'm on felony bond, then I haven't been convicted. And if we believe in the presumption of innocence, why would we have a special rule that says we will, in this case number 2, even if you haven't been convicted in case number 1, but you were on bond in it, why would we make something mandatory in case number 2? Does that answer your?
Well, I think you're trying to explain to me the presumption of innocence in case number 1 would say it shouldn't be held against me in case number 2.
Right. You said that way
unless
clearer
and
than me.
until I'm convicted.
Right. And the other thing to know is that even without special rules, there are other special rules. We got 48 of them. There might be other ones that apply, or there's general discretion that a court has as well. And so there are other paths to get to where people may want to go without making this felony bond mandatory.
Okay. I appreciate that. I only muddied the waters, but it gives me something to contemplate. Thank you.
Certainly. Additional.
I think the bottom line rule is don't break the law in Butler County.
Well,
Okay,
but we just don't break the law.
there you go.
All right. Any other questions, committee? All right. Thank you very much, Ms. Roth. I see no neutral or opponent testimony. Is there anybody else that would like to speak on behalf of this bill? Seeing none, we'll go ahead and close the hearing on House Bill 2068. And we'll move on to House Bill 2069 and ask Natalie to give us an overview.
Thank you, Mr. Chairman. House Bill 2069 amends KSA 223722 to provide that post-release supervision shall not toll except as provided over in KSA 755217, which is the statute that provides for the procedure when a person has violated their conditions of release. And I can take any questions.
Questions, committee? Seeing none, thank you, Natalie. Oh, hold on, Representative Heiberger.
Carmichael question?
Yes, thank you, Mr. Chair. I wanted him to be able to ask it this time since I'm actually prepared for it. You guys heard this bill actually in 2018, so it's been a little while ago. It was House Bill 2603. It passed the House 117-0, and then it died in Senate committee.
Very good. All right, thank you very much, Natalie. All right, we are going to invite Jessica Domi up from the Kansas Sentencing Commission. Welcome to the committee.
Thank you, Mr. Chair and members of the committee. We thought we'd give Scott a break this afternoon. So my name is Jessica Domi. I am the Attorney General's designee to the Kansas Sentencing Commission, and I have served in that capacity since 2015. So I appreciate the opportunity to speak with you this morning or this afternoon on House Bill 2069. I've had an opportunity to read through the submitted testimony, and I'm a firm believer in not to read to you what you have in front of you. So if I can't just tell you why this bill is important. It seems pretty simple. The bill enacted says that the post-release doesn't toll. Why does that make any difference? Well, the case law that I attached to our testimony is why. So there is a lot of sentencing rules, as we just learned about, that come into play when you're sentencing someone. So if someone is on post-release supervision, and post-release supervision is where they have served their sentence, they've served their prison term, and they've been released. And they're on that period of release after prison for either 12, 24, or 36 months of post-release supervision. During that time, they're supervised by the Department of Corrections. If they're arrested on a new case, and they're in custody on that new case, generally the Department of Corrections is probably going to issue a warrant and hold them on a post-release question. Have they violated their post-release? And so they serve them on that post-release warrant when they're in custody, and while they're awaiting disposition on those new charges, that warrant stays on there because they're not being transported back to the prison to deal with that yet. They're facing the new charge. And while they're in there facing the new charge, they term out. So maybe post-release was 12 months, they had 6 months left of it. They're sitting in there waiting for their new charge to be disposed of, and they burn up all 6 months of that post-release. Well, at that point, essentially the post-release is discharged because they've served all the time in there that they can serve. The warrant's been on a hold on them the whole time, but they haven't come back for that formal disposition. And so while they're serving that time waiting for disposition of the new case, there's jail credit accumulating, right? So why is this important? Well, the question becomes, when that new case has a disposition, where does the jail credit go? And we have a lot of different rules, and the Hook case, which I pointed out in our testimony, is if you're in custody solely on one case, that's where your credit goes, and that's pretty clear. We know that, okay? But if you're in custody on a post-release case and on a new case at the same time, there's a question about who gets the time. Generally, if they're on post-release and that warrant's been served on them, the time from the warrant being served and the time that that warrant is released or that post-release is discharged should be awarded to the post-release case. And that's generally what KDOC has done. And then the time from the time the warrant is done or the post-release is discharged until disposition of the new case would go to the new case. This is also because we have a sentencing rule that says that if you're on post-release, your new case has to be consecutive to the case in which you were on post-release on. So you can't double dip. You can't get credit for post-release and get credit for the new case. There has been some unpublished decisions by the Court of Appeals, right or wrong, that has said, wait a second, we think you can't just say that this has to go to post-release. We think maybe it should go to the new case. And so when it comes to sentencing on the new case, some courts are interpreting that they have to give all that jail credit to the new case, even though it probably should be going back to that post-release case, and it does once it gets to the DOC for sentence computation, which is making the law being applied differently in different jurisdictions in this case. And so the reason why in 2018 KDOC brought this bill was to say, hey, we operate under this premise that post-release came first. This time should go to post-release. If you read the post-release statute, it says nothing's in there saying it tolls. So it's going on, and that time is continuing it, and they get credit for that time. And so if you have a bill that says that nothing in the statute tolls that unless something else in the post-release statute says, then it's clear that the legislative intent is that that time that they're in custody on a post-release hold goes to post-release. And then the time that they're solely in custody on the new case goes to the new case. So when we go to sentencing on the new case, we know what time goes to post-release and what time goes to the new case without having to wait for them to go back to sentence computation at DOC and try to figure out jail credit and send back non-protuncs and have to resentence and award issues. So that's really why it seems very simple, is that KDOC normally operates under this premise, but there's been some unpublished decisions out of Saline County that have said that maybe it should be awarded differently. And so we wanted an opportunity to clarify and say, no, it does not toll. The amount goes to the post-release. So if I haven't confused you on that explanation, I will stand for any questions. Thank you, Mr. Chair.
Absolutely. And I was going to say, these are some pretty deep topics, and there's a lot to understand. And with new committee members, the old cliche saying there's no stupid questions, there really isn't, because these are really important topics, and you really do need to understand it. So Representative Slingenstiepen.
Just a point of understanding. You've used the verb tolls 3 or 4 times, and what does that mean in this case?
So in this case, the way the legislation is drafted, it says that the post-release period does not toll, meaning it doesn't stop. That period continues to run so that they're getting credit towards that post-release while they're in custody.
Okay. Thank you for explaining that. Thank
Yes.
Yep, absolutely. Representative Titus.
Thank you, Mr. Chairman. I see the reference to 75-5217, and it's quite long. Could you give me a brief summary of how that would, what the exception would be when it would toll?
Yes, and I think DOC can answer that as well, but
I'd rather wait, that's fine.
I can attempt. So I'll attempt.
I don't need to, I just want an idea of what the.
Yeah, so I read through that statute as well as we were preparing for testimony. That statute talks about the issuance of the warrants and whenever there's a post-release violation and how that would toll. There's specific findings, I believe, as to whether somebody is a fugitive from justice. That is when that tolling would kick in. And so I think the representative from KDOC will address that specifically, but there is a specific provision in that statute on when it does toll. This is saying that this warrant being served does not toll it.
This may be a better question for the reviser and my lack of knowledge in the criminal statutes, but when it reads the service of the post-release supervision, it strikes the ear funny. Is that the common way that's said, or could it be said something like time served, or others would know better? It struck my non-criminal lawyer eye funny.
So we believe, we view post-release as a part of the sentence. So when you say the service of your post-release period means that is time you have to serve on post-release. So it's time that you would serve in custody is your prison sentence, time you would serve on post-release is your post-release term. So I believe that's why they use that verbiage. Even though you're not in custody, you're serving your post-release time.
Okay. All right. Additional questions? All right, seeing none, thank you very much.
Thank you.
Absolutely. And we'll now welcome Randall Bowman, Executive Director of Public Affairs for the Kansas Department of Corrections. Welcome.
Thank you. Thank you, Mr. Chairman, members of the committee. Randy Bowman again, privileged to be before you on behalf of the Kansas Department of Corrections. And it's my privilege to get to follow Jessica on this, who can get through all the legalese, because most of you may not yet know I'm not an attorney, so I'm the lay person like the rest of you. But just really simply, she outlined what this is trying to do very, very well. It's something that has been in practice, trying to apply the law as we think it has, and until a few of these decisions she made, it wasn't really in question, is my understanding. So this goes back until at least the mid-1990s. This is the way business has been done. That if you're arrested in that scenario, your time counts off of that post-release supervision. So really to us, again, Natalie mentioned it, so we tried to bring this to the committee and your predecessors in the House, and you saw fit in 2018, but it languished in the other chamber, I guess is the best way I can say that. So we do support this. We worked with the Attorney General's Office, the Sentencing Commission this fall to bring this to your attention, and hopefully you will see forth to move it forward. If I may, Mr. Chair, go back to Representative Titus's question. So the best way I can try to explain it is when it does toll, when it does pause, that involves people who are in another state. So if they were in another state under supervision, get in trouble there, and then that's going to run its legal process. So they're not available to Kansas to come back. Another possible scenario, that is they ran to the other state, so they absconded to the other state. Again, there's going to be a process before they can be returned to Kansas, so that time does toll under the law. Those are the primary examples, at least. There might be another one I'm not aware of. So with that, we thank you for the opportunity to stand for questions.
Sure. Any questions for Mr. Bowman? Representative Carmichael.
Thank you. As I was listening to the prior testimony, I heard mention of Saline County. That's a place somewhere far away from Wichita. Is that the only place where it's being calculated in the manner that was described that this legislation seeks to fix, or are there other counties where this grave miscarriage of justice must be occurring?
Chairman, Mr. Representative Carmichael, talking with our staff who do this, to give me a little background on it, this happens with some regularity where they just have to on the phone help primarily newer attorneys, it sounds like, wrestle with it. But the two counties who were specifically given to me examples where this comes up are Saline and your home county of Sedgwick, sir.
Well, we've had a judge on the criminal bench retire very recently, so we will see. One brief additional follow-up, but when the calculation is made in the manner in which this legislation seeks to change, when these folks get back to DOC custody, as I understand it, you do a computation there, and then there was mention that it goes back and ends up on journal entries, nunc pro tunc, et cetera, presumably to correct what some might call a computational error. Is that what happens, or are judges being steadfast in their original interpretation and saying, no, this is what I sentenced, and I'm not going to change it?
Mr. Chair, Representative Carmichael, my understanding is that does occur where this kind of run up through the court system or the appellate system, so we've had to do some of that. It's around when they do formally discharge, so they're off of that first case for some period of time. As to why and the judges remain steadfast, I'm not sure I know that detail as to how they arrived at their decision.
But in the end, if this is a miscomputation, which it sounds probably like it is, does it get corrected somewhere, or do we have people who've ended up arguably spending too much time in the custody of the Secretary of Corrections because of the lack of a statute like what we're discussing today?
The accounts, Mr. Chairman, Representative, the accounts that have been shared with me is yeah, we have to go back and recalculate all that stuff. So there's some administrative burdens to that. Best we know, no example was shared of me of like, ooh, we really missed this one and they spent too much or spent too little, I suppose, is another scenario that could present itself.
Well, I appreciate the department's efforts to get these things fixed, and if we can make your job easier, I'm sure that's what we're here to do, Mr. Chair. Thank you.
True then. Any additional questions? All right, seeing none. Thank you very much, Randy.
Thank you.
All right, I don't see any neutral or opponent testimony. If there's nobody else that would like to testify on this bill, we'll go ahead and close the hearing on House Bill 2069 and open the hearing on House Bill 2070 and ask Natalie to give us a review.
Thank you, Mr. Chairman. House Bill 2070 allows certain non-drug offenders to participate in the Certified Drug Abuse Treatment Program. You guys commonly refer to that as the Senate Bill 123 program. The bill amends KSA 216824. That's the statute that creates that program. Current law there requires that offenders have to be convicted of certain drug offenses to be eligible to participate in that program. This bill would allow offenders convicted of non-person severity level 7, 8, 9, 10 felonies with a criminal history score between C and I to participate if the offender has no prior convictions for manufacturing a controlled substance, cultivating or distributing a controlled substance, or unlawful acts involving the proceeds from drug crimes. And then offenders who are convicted of a non-person severity level 7, 8, 9, or 10 felony with a criminal history score of A or B would be able to participate if they don't have those same prior convictions that were listed above, and the person felonies in the offender's history were non-drug severity level 8 or lower, and the court finds that the safety of the members of the public will not be jeopardized by placing that individual in a certified drug abuse treatment program. And I can take any questions.
Questions for Natalie? Go ahead, Representative Heiberger.
Carmichael?
Thank you, Mr. Chairman. This bill, it's pretty heavily modified, but last year you guys had House Bill 2128, and as originally introduced, that bill contained some provisions that were very similar to this, trying to accomplish this goal. The House committee stripped those provisions, so you were just left with a jurisdictional issue in that bill. So this year, we're taking these provisions. We kind of changed how they were drafted a little bit, but they're to accomplish the same goal.
All right. Oh, Representative Titus.
Thank you, Mr. Chairman. Natalie, could you give me an example of what a non-person severity level 7, 8, or 9 felony might be, just to?
I'm trying to think of, Scott will be able to, he does the proportionality statement, so he's back there just like listing them off the top of his head, so he'll probably, theft and forgery. I'll let him expand on that for you, yep.
Thank you, Natalie. All right. Mr. Schultz, welcome back to the committee again.
Thank you, Mr. Chair. Just enough time to get my breath. So yes, Representative Titus, these are low level. If you recall, and again, I'll pull out my my visual aid. These offenses, and if you look on the testimony, basically the ones that are in the bottom group, these are the least serious offenses of the felonies. Now, keep in mind, these are only felonies we're talking about. So these are offenses such as theft, as forgery, identity theft, some burglaries, those type of crimes. They don't include person crimes such as criminal threat and those that would be injurious to people. So we were very clear, the commission was very clear on making sure that the individuals at this point would only be in non-person capacity that they would be eligible. As Natalie indicated, most of you are a little bit familiar anyway with the Senate Bill 123 program that the Kansas Sentencing Commission administers. We spend about $600,000 a month paying substance abuse treatment providers in your jurisdictions to treat individuals that have been convicted of possession of controlled substances, or in some cases, small sales of controlled substances. If they fall under the criteria of the statute, the court can order them into treatment. So community corrections, they're out on probation, they are supervising these offenders, and they are required to go to substance abuse treatment. If they fail to do that, they can be revoked and sent to prison. So that is the current Senate Bill 123 program. This would expand that, and what I call Senate Bill 123 plus. It would now allow us from having folks eligible in drug categories, now extend that into and expand it into the non-drug realm, to those non-person felonies. Why do this? We know that individuals that are currently being convicted for these offenses of theft and burglary and forgery are doing that because they have addiction issues. And that currently, even if they do have addiction issues, they are unable to actually get Senate Bill 123 or state-paid treatment. They still can actually get community-based treatment. and that happens right now. If I get convicted of theft, I go through and have a risk assessment done as part of my probation, and if that discloses that I have a alcohol drug issue, then I can actually receive that. But it's from community-based type of treatment. In this situation, state will now pay for that, freeing up resources in your own communities for other individuals. So this is a situation that the commission believes very strongly about. There is a fiscal note on this based upon the number of individuals we believe would be eligible for that, somewhere to the tune of about $500,000 up to about, I think we have $1.7 million that would be needed to be appropriated for these new offenders coming into the program. We already have the infrastructure set up as far as the bill payment. We have a vendor that pays the bills, the treatment providers that are certified. We have about 120 of those throughout the state. Those would be the same treatment providers. So the infrastructure is already there. We merely need to actually extend this to those non-person folks. The commission has actually even gone to the extent of looking at the criteria. In the bill, it actually calls for a decision by the commission to determine those thresholds required to be able to participate in the program. The commission has already actually undertaken that. We had several meetings with in fact, Jessica Domi is actually the chair of the Assessment Selection Committee of the Commission. We met with two experts that we have used many times, Dr. Alex Hulsinger from UMKC, as well as Ashley Bauman, who actually authored the tool that is used statewide for women to actually determine what these thresholds should be, so that if there's any questions by the committee as to what those potentially are, we have actually already in advance tried to be prepared for that in case the committee is interested in doing that, what those thresholds are. We're actually looking at when those risk assessments are done, which they are done in felony cases, there are domains on those assessments that cover alcohol and drugs. And the committee has actually labored over making decisions as to what thresholds are required for somebody that's convicted of theft, for example, to actually be eligible under the program. So part of the issue is, because these are only felonies, about 85% of all of the felons, that's drugs included, are represented by counsel and are by appointed counsel. So that means that they're indigent. So 85% of the folks going through the system actually require indigent counsel. What that really means on the substance abuse mental health side is that they most likely don't have health insurance to pay for substance abuse treatment. This would allow for them to actually get the treatment that would be required in those instances to hopefully be able to keep them from recidivating with the thefts, with the identity thefts, with the forgeries, and those type of non-person crimes. So with that, we would ask you to support this, and I would stand for questions.
Questions, committee. Representative Mon.
Thank you, Mr. Chairman. So will there be any requirement that they be indigent and not be able to provide treatment for themselves before they're eligible for the Senate Bill 123?
Representative, there would not be. We do have, and I will tell you, in the Senate Bill 123 program, we do have folks that actually have their own insurance. And so we are set up to actually be the payer of last resort. So there are folks that actually come into the program that their family or they themselves actually have private insurance. That would actually be taken care of. It would just be those folks that were indigent. So there wouldn't be no requirement.
And on another issue, now, Senate Bill 123 is normally supervised by community corrections, is that right?
That's correct.
Which is, at least in my experience, seen as a step up from adult court services probation. So are these, I mean, is the court going to be required to put these folks into 123, or do they have the discretion to put them in court services probation first and then graduate into 123 if they mess up there?
Representative, that's a great question. Currently, the way the statute is written, all of those Senate Bill 123 folks are required to go into community corrections, and that is that's how the supervision scheme has actually been since it was promulgated in 2003. Because this is actually written in and amended into 216824, which is the Senate Bill 123 statute, it would continue to actually have community corrections folks. And I understand what you're saying. You know, community corrections is normally termed as the intensive supervision. Our experience has been the way that we have the process and the program set up is that court services does not play a part in that. Any change would require a fairly large administrative change to actually allow court services to actually be involved with that.
My concern is simply that folks who, normally the reality is you get kind of two bites of the apple. You go to court services, you mess up in your probation, you end up in community corrections, and then if you mess up again, you end up in prison. Generally, may take 3 or 4 bites of the apple, but that's kind of the progression. My concern is if we put folks directly into the Senate bill and they have one mess up, are they going to now be ending up in prison? And I know it's may not be a question you can really answer because it's going to be up to the individual judge at the individual time, but that's kind of my concern about putting these folks that are low-level felons directly into Senate bill or community corrections. So I don't know if you can address that or
I agree with you, and that is what you've described is the normal logical progression that if they are unable to comply in the court services setting, very often that is they're bumped up now to a more intensive. You're reporting more often. You have more requirements as a result of the issues with court services, and that would be something that we could potentially look at. Though I think that's a great way to look at potentially at that. That would be something I think that we could go back and talk with court services to see whether or not that would be a possibility.
Additional questions, committee? All right, seeing none, you're off the hook.
Thank you.
All right, committee, there is written proponent testimony from James Houston Bales, Public Defender, on behalf of the State Board of Indigent Defense. And I don't see any neutral or opponent testimony. Anybody else care to voice an opinion on this one? All right, so it is. We'll go ahead and close the hearing on House Bill 2070. And seeing nothing else on the agenda for today, we will be adjourned.